All right, so we are going to go ahead and get started. My name is Elizabeth Aloni, and I'm with Schneps Media. Schneps Media is the largest local media company in the New York metro area with over 100 media outlets from Manhattan to Montauk. And today we are thrilled to be hosting this very important webinar, Top 5 Elder Law and Estate Planning Topics for the Thanksgiving Table. Thanksgiving is a time when the family gets together and we all reflect on what we're thankful for. I know in my family, we all go around and share it. And this year, use this as an opportunity to discuss your future plans and goals. And today we have an expert on elder law and estate planning to help us prepare for that important conversation. I am thrilled to introduce you to Melissa Negrin-Wiener. Melissa is a senior partner at Cona Elder Law. She manages the Government Benefits Department, concentrating her practice in the areas of asset protection, Medicaid eligibility planning, estate planning, special needs planning, mediation, guardianships, and veteran benefits. She supervised the preparation of Medicaid applications for nursing home care, home health care, and community benefits, resolves complex Medicaid issues, and represents families facing a reduction in Medicaid home care hours and services. It's truly a pleasure, a privilege, really, to welcome her, especially as she was recently honored by Schneps Media for her outstanding contributions to both legal community and the broader community, earning a spot on the prestigious Long Island Press Power List. Welcome, Melissa Negrin-Wiener.
Thank you, Elizabeth. Great to talk to you again. Thanks for
Yes,
having me.
absolutely. Absolutely. So let's dive in because there's a wealth of information to cover. One of the questions that comes up right at the top is, what is the age to start planning?
So, this is an interesting question and something that I try to really educate the public about at every chance I get. Planning is for everybody, but it just looks different at every age and every stage of life. So, we always tell people once someone turns 18, they should start at least with the basic documents, power of attorney, healthcare proxy, living will, because once you turn 18, there's no one with the legal authority to handle any of your financial or medical needs or concerns if you were to become incapacitated, right? So this is all about planning for the what ifs. And just like insurance, like you hope it never happens, but you need to have it, right? So it's the
Yeah.
same type of thing. So um, you know, again, around the Thanksgiving table, all of the kids come home from college. They're just at that time of their life where they've turned 18 or they're 19 or 20 or whatever it is. And hey, you know what? We never really talked about this. Maybe they need to get those documents into place. Um, a lot of times as parents, we feel like, well, they're 18, but they're like still kids, right? I mean, my oldest is 15. I can't imagine in 3 years I'm going to feel like she's an adult. And so you kind of feel like as a parent, you should still have all the rights to do those things, but you don't legally. So, you never want to be the one to get that phone call of something happening off in college, across the country, and you can't get the information because you don't have the healthcare proxy and the child can't give permission at that moment in time for the doctors to speak with you. So that is kind of the baseline. Like that's where you start. At 18, you should start and at least just have those documents in place.
That's a really good point because I think people have a misconception about that. Being a parent, you're paying the bills, that you'll be able to get access to all that information. So what are some of the other common misconceptions about estate planning?
So I guess, one of the things we talk about all the time is some people think that estate planning is, just for millionaires kind of thing. Estate planning is just for people who have lots of assets and lots of properties and maybe businesses and things like that. But estate planning is really for everybody. Again, it just looks different depending on who you are and what your situation is. So we always say you're never too rich, you're never too poor, you're never too old, you're never too young to plan. And it's not about um, what I see a lot, it's not about being old or being ill that you should, oh my God, we need to plan now. It's something that you should do from the beginning while you're young and healthy and able to, put things in place for later.
No, it's a really good point. So getting those misconceptions out of the way, what are some of the biggest mistakes people make in regard to estate planning?
Some of the things that I see, one of the things that kind of makes me crazy is people create trusts, right? Whether they're irrevocable trusts for long-term care and Medicaid planning purposes, or they're revocable trusts that they're creating to avoid probate for their family members when they pass away, but they don't fund them. They don't put anything in them. And I
Mm,
can't tell you how many times I've had people come in where they've done a trust, years ago. For example, with an irrevocable trust, there's a 5-year look back for Medicaid. So you put your assets into an irrevocable trust. If you need Medicaid in a nursing home down the road, Medicaid's going to look back 5 years to see what you've done with your money. Well, if you put everything in the irrevocable trust 6 years earlier, then everything in the trust is protected and Medicaid can't touch it. And I've had so many instances where people have come to me to do the Medicaid application. I look at a trust that wasn't out, not our trust, but something they bring with them. And I'm like, okay, what's in here? And they're like, what do you mean? And I'm like, well, what's in the trust? So that I look at the deed and I see the deed is still in mom's name. I look at the bank accounts, they're still in mom's name. It's like this kind of misconception or mistake where it's like I created the trust and now everything is automatically there. And you have to actually take the steps to put the assets into the trust. That's a big part of what we do for our own clients when we set
mhm.
up the trust to, kind of either lead them through it or in some cases do it for them to get those assets into the trust. I think that's one of the biggest mistakes I see.
Mhm. Yeah, and that's something you really can't go back and change. Once the
Right.
time is there, the time is there. So you
Exactly.
mentioned revocable, irrevocable. What's the difference between those two types of trusts?
So they're first of all, they're both living trusts. People often ask that question, what's a living trust? A living trust is just a trust that you create while you're alive, as opposed to one that is created in your will, for example, when you pass away. So a living trust can be either revocable or irrevocable. If it's revocable, usually you're the trustee. You can change it, you can amend it, you can break it, you can do whatever you want with it. It's yours, you have full control. But when you pass away, whatever in the trust is going to pass to the beneficiaries of the trust without having to go to the courts, without having to probate a will. It controls all of the assets that are in the trust, which is again why it's very important to put assets into the trust. An irrevocable trust is different. An irrevocable trust is set up so that your assets are being preserved. So the revocable trust does not protect the assets for Medicaid for long-term care purposes because you still have total control. The irrevocable trust has an appearance of, or is, essentially taking some of the control away. So you're putting the assets into the irrevocable trust. You can no longer just walk into the bank and take money out of that irrevocable trust. You do have the ability to change your trustees anytime you want, but you cannot be your own trustee. You have
Hmm.
the ability to change your beneficiaries anytime you want by making a new will, because the will ultimately control what happens to the assets in the trust. But you can't amend it. There's a lot more kind of control given to the trustee than to the grantor, right? Because look at it this way, when Medicaid looks at the two trusts, well, with the revocable trust, they're going to say, just go take the money out and pay for your care, right? You have access to it. With the irrevocable trust, you can't do that. So it blocks Medicaid from being able to say, go in and pull out that money. So it's
Mm.
protecting it.
So in terms of when you have an irrevocable trust, obviously you have to have a trustee. So how should someone choose who should be in charge of decision making, in their while they're alive and after they pass away? I mean, obviously there's other things other than the irrevocable trust. Maybe you can share about what those other things are that we have to assign people to. And if you could share with us, like how do we choose that person?
Sure. So basically you're choosing a power of attorney, right? So a power of attorney is financial. Who's going to make financial decisions for you, make sure your bills are paid while you're alive if you become incapacitated. File your taxes, apply for Medicaid on your behalf, anything kind of financial in nature. So obviously you're going to want to pick somebody who either is very good with those types of decisions and very good with finances, or smart and comfortable enough to know that they need to hire somebody to help them do that.
Mm.
So that's kind of the power of attorney piece. And you can have more than one person. You can have joint power of attorney, two people, three people. But really there, the important thing is that you're dealing with people who are on the same page, who generally work well together, get along, because you don't want to have, a battle at every turn. That's not the goal. Another position essentially that you're choosing somebody for is your healthcare agent. So that's the person who's going to make any and all decisions regarding your healthcare, which in addition, in New York State means end of life decisions. So the person who can ultimately be the one to say to the doctors, to remove life support or withhold it, right?
Mhm.
So it's not an easy task, not an easy job. Of course, if you have somebody in the medical field, that seems to be everybody's kind of go-to in their families if they have somebody who's in the medical field. But you have to think about again, who can make those difficult decisions, who's most likely to follow your wishes, no matter how difficult a decision it might be. A lot of times when I sit down with people, they'll right off the bat, they're going in age order, right? And sometimes that's not the right person.
Mhm.
Uh, then you have to choose your executor, who's the person who would control the estate or handle the estate after you pass away. And that's pretty much financial. So it's the same kind of job almost as a power of attorney. A lot of times people will choose the same individual for those jobs. Um, and the trustee. So especially when we're doing an irrevocable trust, I prefer people have co-trustees, two trustees, because there are certain instances where we may need to withdraw money from the trust or pull money from the trust, and we need to make sure that we have more than one person available to do that. But it's very important that these people are on the same page. They know that they're co-trustees. They know that it's expected of them to work together and handle these things and not, again, battle at every turn. That's the last thing you want. And luckily, I haven't had to deal with really much of that. People are very good about making sure that if they have co-agents, they're people that work together, but we all know anything can happen, right? At any time. Um, so my biggest piece of advice to people when choosing those agents is really to think about the job at hand, and we talk a lot about what the job is and
Mhm.
who makes the most sense for that position.
And that I think underlines why these conversations are so important to have with your family. And this Thanksgiving is a great way just to even get started with it because you're going to have to talk to them about these things. Who's going to be named for X, who's going to be named for Y.
Right.
Um,
And even if you don't want to necessarily talk about it at the Thanksgiving table, think about it. Right?
mhm.
Like sit back for a second and look around and say, like what makes sense here, right? Who would make sense? And
Yeah.
sometimes I tell people, think about like what's your gut reaction, and then think about it, and what's your actual decision and the difference between the two, because it is very often a gut reaction for people. They go in age order. They don't want to leave anybody out. They don't want anybody to feel bad. But at the end of the day, that's not what it's about.
Yeah, that's a very tricky thing and important to realize.
Hmm.
So you had mentioned you were talking about with the revocable and irrevocable trust, you were talking about a look back period.
Hmm.
Share a little bit, and maybe we don't, not everyone doesn't know exactly what that means and what that entails.
Oh, sure. So there are really two different types of Medicaid when we do planning for Medicaid. There's community or home care Medicaid, where an aide would come into the home. And then there's nursing home Medicaid, where you're actually in a nursing facility. So the Medicaid applications are very different. And for community Medicaid or home care Medicaid, there's no look back. So you could give $1 million away today and you could qualify on the first day of December for community Medicaid. Now, there's been talk of a look back since before COVID,
Mhm.
of potentially 2.5 years coming down the pike, maybe mid 2025. we don't really know if that's happening or not happening. We'll certainly know more in January after we have our annual, the annual elder law update to the New York State Bar Association. And we'll find out what's happening. But right now, there's no look back for community Medicaid or Medicaid home care. But for nursing home care, there's a 5-year look back, and that's a period of time. It's the same for everybody. That Medicaid, if you're applying for nursing home Medicaid, they look back at 5 years of your bank statements. So we have to provide every monthly statement for every account, whether it's a trust account, a checking account, an annuity, an IRA, whatever it is, and they look at all the transactions for the past 5 years. And they want to know everything that you've done with your money, because if you've gifted it or given it away or put it in a trust, made any sort of uncompensated transfer, they're going to assess a penalty. They're going to say, you're not eligible for Medicaid for a specific amount of time, depending on how much you actually gave away that was uncompensated.
So another reason why it's so important to do this as soon as possible. So money that's moved is moved before this 5-year look back period, right?
Exactly, exactly. And we tell people all the time, especially here on the island where the house is typically the largest asset,
Hmm.
even if you just put your house into the trust, because sometimes people aren't comfortable parting with that kind of control, especially early on in like retirement, let's say, because this piece of planning, usually people start to look at around 60, 65, this
Hmm.
part of it. And maybe they're not completely comfortable giving up control of all of their cash assets. So just get the house in and get that clock started on that asset. And then as time goes forward, maybe we do some other planning.
Is that a good way to be able to protect your home for long care purposes? Let's say you want to stay home and you
Hmm.
don't want to have that affected.
Yeah, that's the way to
If
do it.
if you don't and you have your home, they consider that an asset, and that would then, is that true or?
So in New York, you can qualify for Medicaid even if you own a home, as long as the equity in the home is not over, it's a close to 1,000,001 right now. So if your equity in your home is less than 1,000,001, you can still qualify for Medicaid and keep the home in your name. The catch is when you pass away and your home goes through probate, Medicaid can come back and collect against your estate what they've paid out over your lifetime that you've been on Medicaid. So you could potentially lose the entire value of the house at the time you pass away. So doing the planning gets it out completely so that it can't be recovered down the road.
That makes a lot of sense. So what would you say would be someone's first step? They're listening to this, they're looking around their Thanksgiving table, they're assessing. But what's the first thing that they should do to really get this started?
So, I mean, listen, I tell people all the time, just reach out. We have 3 offices now. We're in Melville, Port Jefferson, and Garden City. So we can pretty much touch the whole island and the boroughs. And what we do is we send you a questionnaire. And I think that that's a great starting point for people, even if they're not necessarily ready to come in yet. You have the questionnaire and you can start putting together all of the information. Who are your family members? What are your assets? Whose name are they in? Who's the beneficiary? How much is in the account? All of those things are on the questionnaire. So it really helps people kind of put the whole picture into focus.
Hmm.
And then we sit down and talk about, okay, how old are you? How is your health? What are your goals? What are you looking to do? And based on that conversation, we're either talking about, again, just a power of attorney healthcare proxy living will. Maybe we're adding a simple will. Maybe we have younger people on who have minor children, and we want to just make sure we have guardians named for the children if something happens to both of those parents. Or perhaps we're a little bit older than that. We have grown children, we're still working. So maybe we just need to make sure we have wills so that everything goes the way we want it to go when we pass away. Maybe our children are married and we don't want assets going to our son-in-law or daughter-in-law. We want to keep things in trust for our children. So we want to build that into our will. And then as we get older, then we start talking about the asset protection, the trusts. And then, of course, we have the other kind of whatever percent group of people where their assets are in excess of the estate tax limits now, and we have to do some tax planning, which is, less of the population, obviously. At this point in New York, you can pass away with about $7 million before you get taxed, and federal numbers are almost 14 million. And that's going to sunset in 2020, at the end of 2025, beginning of 2026, and probably come down. I think it's supposed to come down to New York's level. But there's a lot of tax planning people can do if they're in that, that arena. So just starting out with a phone call and a questionnaire is going to give us a very, very clear picture of what kind of direction we need to send people in.
There's so much to it. You always bring up, you talking about, let's say, a will, and then you mention this in-law, the son-in-law and the daughter, and there's so many intricacies, in this planning. And I know that people look online and they think, nowadays we can do many contracts we think online, and there's a lot of offerings that we think we can do ourselves. But why is it important to hire an attorney who specializes in trust and estates and in elder law?
Yeah, so you asked me before, one of the biggest mistakes that people make, and the online documents are one of the biggest mistakes that people make. And I see them all over. I see them pop up on commercials, these different, websites that have legal documents, and you just go in and you type who you want, but you're missing that human interaction of having the conversation, right? The
Yeah.
conversation where I would say to you, okay, who do you want as your power of attorney? Do that, oh, well, you know what? Maybe the person who's filed for bankruptcy 3 times isn't the right person, even though it's your oldest son, right? Like you're missing that conversation with
Right.
the computer when you're, when you're just typing that online.
Yeah.
Um, the reason why it's so important to have, the meeting with an attorney who specializes in this area, and not really supposed to use that term specialized, but who practices in that area, is really about experience. We've seen it all. I've been with Cona for I think almost 24 years now. And I was 24 when I started, which I can't wrap my brain around, but
Wow.
this is what I do. So I've seen it all. I've had the conversations. I know what people worry about, and it doesn't take me long when I sit down at the table with a potential client to kind of get the idea of what's going on, and being able to kind of pull from those prior experiences and say, well, it sounds like maybe this is a concern, and we can do this way, we could do it that way. The other big piece of this is the estate planning and elder law overlap. So in my mind, if you're not in that tier of people who are doing tax planning, you're doing estate/Medicaid planning, right? Because you may have long-term care insurance, which is a great tool, and I refer people a lot to check out long-term care insurance. But if for some reason they can't qualify for it medically, or it's too expensive, or maybe they have it, but it was too expensive to buy the top of the line plan, so they have some coverage, but not enough that it would necessarily cover, a nursing home long term. They want to plan for Medicaid to be a supplement down the road. So I
Mhm.
don't look at it as estate planning versus Medicaid planning. It's kind of one thing, right? So if I'm doing planning and I don't know the Medicaid rules, then how am I doing the estate planning/Medicaid planning for that individual? And that's why that elder law piece is so important,
Mhm.
because we anticipate what could be coming down the line and how the estate planning needs to be done to protect the assets. So you're really killing two birds with one stone. And some people, they do their estate planning and they forget about it. Like, oh, I
Mhm.
have my will, I have my stuff, and then something happens health wise, or whatever, and they go and bring their stuff in, and it's like, wait, we missed a big piece of this because they weren't thinking about that. That's my job, right? To tell
Right.
you what you need to be thinking about.
Well, speaking of that, how often should someone look at these documents and think about updating them?
So we like to tell people 2 to 3 years, but that doesn't necessarily happen. And I get that because life, right?
Hmm.
So the other kind of way to gauge it is really major life changes. So marriage, having a kid, buying a house, um, a promotion perhaps, or a change of job, or maybe a divorce or retirement. So any sort of major kind of life changes that go on should trigger that, alarm to go ahead and take a look at things and see if you want to make changes. Another big one is making changes to your beneficiary designations, right? Because you can update your will, but if you have a life insurance policy or an annuity or an account with a beneficiary named, you need to remember to update those beneficiaries if you're making changes, because that's going to control what happens to that asset, not the will.
Mm. There are so many intricacies. I mean, I think that answers the question right there, and why you need an attorney who specializes in both, both of these pieces, because you don't know what you don't know.
Right, right.
I feel like that's, you always bring up something that's like, I didn't think of that, you know? So, I mean, I think that, to me, just as a layperson saying, that to me would be peace of mind to know that it's not just all up to me to figure out the what ifs. And you have 24 years of what ifs. So,
Right.
very, very helpful. We have so many questions. Would it be okay for you if we jump into some of those?
Yeah, no, I see them popping up.
Yeah, very exciting. Um, Let's see. So, what steps, an anonymous person said, what steps does one take to put assets into a trust?
Okay, that's a good question. So, if you're putting property into a trust, like a home or a co-op or something like that, it's actually a change to the deed. So, there has to be a new deed prepared, transferring the ownership of the property from you to the trustee of your trust. If it's a revocable trust, it's going from you to you as the trustee, but you still have to do that in order to actually change the ownership of the property. Um, bank accounts or other assets like life insurance, you're doing a change of account name. So if you have, say, a brokerage account, let's just say with Schwab, right, your statement is not going to say Elizabeth Loney. It's going to say David Smith as trustee of the Elizabeth Loney Trust. So you'll
Mm,
know if your assets are in trust. If you have a trust and you're not sure that you put anything in them, look at your bank statements, because the name on the account is going to tell you.
okay, very helpful. Blessy wants to know, in your experience, how did parents handle POA and executor with their multiple children? Did they make all their children trustees? How can they start the conversation when they prefer one or two children to oversee it?
So, yeah, so it gets increasingly difficult, obviously, the more children you have, right? But it's okay to have co-powers of attorney, co-trustees, but I would never go beyond three. If you have some people, they'll come in, they have seven children, they want to put everybody on. That's just asking for trouble, really. I think you would be surprised at how many of them don't want the responsibility. And so that is a good start to the conversation. Perhaps you have three children and one of your children has five kids and the other two don't have any. So maybe that responsibility is a lot for that one individual child, and they'll make the decision for you once you start the conversation. Um, Short of that, I think you just need to choose what the person who's best suited for the particular role, and also, that you're comfortable that they're going to do the things that you would have done, because that's what these people are doing. They're stepping into your shoes.
Hmm. So it's important to assess that. We have a question from Carol and also from someone else with a similar is, what is the process to assign assets into an irrevocable trust? Do we create the trust first and then transfer the deed to the trust? Would bank accounts and CDs be handled the same way?
Yeah, so it's the same thing. The trust has to be created first because you need to have the vehicle that you're placing the property into. It has to be created from a date perspective, has to be created first. When we do deed transfers into an irrevocable trust, we do them on the same day. So the dates match, but you could do the deed transfer anytime after the trust is created. Um, the CDs, regular bank accounts, typically what's going to happen is you're going to go to the bank, you're going to have the fully executed trust with you. The bank is going to open a new account in the name of the trust and then move your assets over. So they don't typically, and some banks might do this, but typically they don't just change the ownership on the account. They open a new account, so you're gonna have a new account number. They close the old one and then create, put the new one into the trust.
Okay, great. Carolyn wants to know, do trusts ever expire?
Trusts ever expire? So it depends on the trust. Every trust is going to have language in it that I'm going to try to think of the best way to explain this. We learned this in law school. If you talk to any lawyer and you say, tell me about the rule against perpetuities, they might just like collapse on the floor because it was the most ridiculous thing we ever learned in law school, and every lawyer will agree. So the language in the trust is that if the trust has not terminated already by your death or whoever, whatever the terms of the trust say, it cannot exist beyond 21 years after the death of your youngest living beneficiary at the time you make your trust. So yes, every trust is going to have a set expiration date using that rule, and that's just so trusts don't go on and on and on and on forever. But
Mhm.
typically, when you're drafting a trust, someone passes away, the trust is extinguished, everything passes to the beneficiaries. If you want to leave assets in an ongoing trust for your children, it's going to be over at the time of their passing. And then maybe it'll go to their kids and so on and so forth. But those are all going to be dependent on the language in the trust that's going to set the clock for when each trust is extinguished. Does that make sense?
Yeah, so in fact, someone has a question that's kind of touches that. If there's six beneficiaries of a trust, I guess they're asking, does it dissolve after the parent passing, or can the trust be extended by adding grandchildren? Would that be the will that determines how much goes to who?
It depends on the trust, but the general rule is you can say in your trust, I leave everything equally to my 6 children. And it could be outright to them, and then the trust is gone, and that's it. Or you could say, I leave it to my 6 children in continuing trust. So now they each have a trust. Now they each have their own trust. And then to their children when they pass away in continuing trust. So that's just that's when I tell people, tell me what you're envisioning. Tell me what you want to see happen in your own words, and then I will explain to you how that has to happen in the documents.
Mm, that makes a lot of sense. Yeah, because trying to figure it out on your own is not a good idea. Anne Marie wanted to know, if a person was in a nursing home on Medicaid and their home is owned by their revocable trust, can MA collect against the home for care provided at the time of the person's passing?
So that's an interesting question.
Yeah.
And there isn't a very good answer for it. So Medicaid estate recovery is technically only against estate assets. And a revocable trust isn't really an estate asset. But because it passes to the beneficiaries, you don't have to go through probate.
Mhm.
But it's an asset technically of the individual. So Medicaid can still try to pull back a claim. It does frustrate the ability to do it, but really the safest thing to do for Medicaid eligibility purposes is the irrevocable trust, because that they cannot go after.
Right, right. That's what you were saying about. So revocable trust really does not protect you from these look back periods.
Correct.
Okay. Peter wants to know, if you have a bank account in an irreversible trust, but the beneficiary of the trust is different than the beneficiary named in the bank account, which one takes legal precedent?
These are good questions.
These are good questions. Everyone was very nicely prepared.
So in my experience, and I've had this happen too with life insurance policies where people don't change the beneficiary of the account to the trust. If you put a trust into if you put an account into an irrevocable trust, you want to protect that asset. but you have a beneficiary on the account, you have to change the beneficiary on the account to the trust if you want it to pass through the trust when you pass away. Otherwise, it's going to pass to the beneficiary on the
Mm.
account or on the life insurance.
Wouldn't it be one place or the other? It's either in the account or it's in the trust?
So you're looking at two different things. It's either you're looking at the owner versus the beneficiary. So if you own an account and your daughter is the beneficiary, and then you change the owner to the trust, but you don't change the beneficiary, she's still the beneficiary.
Got it.
If you want that account to go to the beneficiary of the trust, which let's say is not your daughter, maybe it's grandkids, right? Then you need
Mhm.
to change the beneficiary of that account to the trust so it passes through the trust.
Okay. Someone wants to know, can you have a revocable and irrevocable trust? Both.
Absolutely.
Okay. Let's see. So many good questions here. What is the benefit of an IRA trust over beneficiary designations?
So typically we do not put retirement accounts into a trust. There are some tax planning reasons where the high-end tax planners, and we have those here in our office, will do that. But as a general rule, your IRA is going to stay in your individual name, not going to be in a trust. So for Medicaid purposes, your IRA actually doesn't even count as an asset. So your distribution, your required distribution counts as income, but they don't even count it as an asset for Medicaid, so you can keep it in your name without, causing a Medicaid problem.
Great. We had a couple questions about IRA accounts, so that was very helpful. With an irrevocable trust, you still have access to everyday living money if needed.
No. For an irrevocable trust, you have the right to income. So if your money is invested or, even if it's in a CD and it's making some interest, you're entitled to that on a monthly basis. Yes. But the principal itself, you do not have access to for regular everyday living expenses.
Okay. So what is the downside? RB wants to know, what is the downside if you apply for community Medicaid? Since you mentioned you can apply right away, can the state come after your assets after death versus a trust?
So you have to be qualified to apply, and to qualify, you can't have more than $31,175. So if you have a bank account with $30,000 in it and you have no beneficiary or joint owner on that account, then yes, the state would come after that account when you pass away to reimburse themselves for what they've expended. But
Hmm.
if you have a beneficiary on that account, if you've put all your money into an irrevocable trust, then they can't come back to collect against it.
Okay. Someone's asking about spousal right of election rule and how it applies to assets inside of a trust, specifically an irrevocable trust that's Medicaid compliant. Um, And how can I protect my assets if I only want to give my assets to my kids? So if you could share a little about this spousal right of election rule.
Yeah, so the right of election is in New York State, you cannot completely disinherit a spouse. So sometimes people will put in their will that they make no provision for their spouse and they want everything to go to their children. The spouse has a right of election. The spouse can say, at that person's death, the spouse can say, hey, I'm entitled to a third, right? And there's no two ways about that.
Hmm.
The monies, when they're figuring out the value of that third, the monies in an irrevocable trust, a Medicaid compliant irrevocable trust, will count as part of let's say the husband's estate, right? Husband passes away, wife asserts her right of election. They're going to add in the money in an irrevocable trust for Medicaid. They're going to add in the value of that account as part of the husband's total estate. So when does this happen? I mean, mostly with planning, it happens when if we put a wife on Medicaid and husband has all the assets in his name, and he disinherits his wife so that she doesn't get kicked off Medicaid when he dies, she's still going to be entitled to the third, but she's only going to be entitled to the third.
Mm,
So it's a way of, kind of minimizing that loss of assets down the road.
got it. Okay. This is really, again, very, very specific. Someone's now saying, does a prenup protect a trust from a wife who has her
That
own?
all depends on how your prenup is created. Some people will waive their right of election. Now, you can waive your right of election, but for Medicaid purposes, that's considered a gift, right? Because you're saying, I was supposed to get this money, but I don't want it. So now it's going to go to the kids. Medicaid says, hey, that's a transfer, right? You're entitled to that money. So you can waive your right of election. In some planning cases, it makes sense, and in others, it doesn't really do anything.
Mm, okay. Marianne wants to know, can you still set up a trust if the deed to your house was already transferred to one of your children?
You can set up a trust, but that deed won't be able to go into that trust unless your child returns it to you, which I wouldn't necessarily recommend, depending on how far into the 5 years you already are with
Okay.
that transfer to your child.
So these all have, there's not clear cut necessarily answers. There is a lot of if thens to be able to determine your particular situation.
Yeah, I mean, I could never just give people advice based on these questions. That's what's so important about the questionnaire and the initial meeting, because there's so much that goes into it. It's not just in a vacuum, a question to say, hey, yeah, go ahead and do this. I need to know the whole thing surrounding it, the whole story surrounding it.
Sure. I put your contact information here too. I'll keep repeating it and send it out when you get the recording of this tomorrow too, so everyone will have that and can reach out.
Great.
Um, Someone wants to know, is there a difficulty in selling a house once it's placed in a trust?
There really isn't. So the trust is the seller, as opposed to the person who had owned the property. The tricky part is that you need to make sure that at the closing, the checks are cut to the trust, right? Because if you, Elizabeth, put a house into a trust and 6 years later you sold it and the checks were cut to you at the closing, you've now pulled it out of the trust, broken the trust, and undone that whole 5 years of planning.
Wow. Yes, you have to be very careful.
Yeah, and there has to be communication with the real estate attorney, making sure they understand that the checks have to be cut that way.
Okay. Um, Jessa wants to know, part of this you already answered, but does Medicaid count your 403B, 401k accounts when they're reviewing your assets? I know you said 401k, they don't.
401k, IRA, 403b, anything that is uh, a qualified retirement account is not counted as an asset as long as you're taking your required minimum distribution. Excuse me.
Okay, great. We have more questions about these nuptial agreements. Does Medicaid recognize a post-nuptial agreement where one spouse waives their right to the asset? Um, this just bounced up. To the asset and won't count a third of my asset towards her Medicaid LTC eligibility. Basically asking, can a post-nuptial agreement
Right. So
change?
it all comes back to that waiver of the right of election and whether or not Medicaid is going to make the argument that that is a transfer. So I can't really tell you yes or no. Medicaid's a very, or the Department of Social Services is a very interesting agency. And you can get different opinions from different caseworkers, different questions from different caseworkers, different decisions from different caseworkers. And you may have to take something like that to a fair hearing to make the argument that the spouse is not entitled under that specific agreement.
Okay. Um, Diane wants to know, her mother's home is in a life estate for myself and my sister. I live in the house with my mother. Does this protect the home for Medicaid purposes?
So if the house was transferred to you and your sister and mom retained a life estate, so so the deed would read from mom to you and your sister, and then somewhere else on the deed, usually on the bottom, it says subject to a life estate for, and it has mom's name. That's a transfer. So as long as it's beyond 5 years, then that house would be protected for Medicaid purposes. The tricky part with the life estate versus an irrevocable trust is that if you had to sell the house while mom is still alive, then you have a whole host of tax issues, capital gains tax. I mean, it's your primary residence also, so that's a good thing. But mom actually would come into money if the house was sold because the life estate has a value based on mom's age and based on the value of the property, the sale price. So if mom is on Medicaid and you sell the house, she could potentially get kicked off Medicaid because she's getting too much money put into her name.
Mm.
So the easy answer to your question is yes, it's protected the way the transfer was made if it reads the way I said, and I'd have to see the deed. But that's again, 5 years has to pass and selling it can be an issue.
Okay. Well, Melissa, I mean, we could talk to you all day long because you are a wealth of knowledge and there are so many questions and so many unique circumstances. Before we get done, one last question. Should spouses plan together? Do you typically have spouses come together or should they each set up their own separate appointment and work through
Yeah,
their own?
so I mean, typically we always have spouses plan together. We do have spouses sign a consent that there are no secrets. In other words, one spouse can't go home and pick up the phone and say, change everything, but don't tell my other, tell my spouse. None of that goes on. But it's Medicaid especially looks at spouses as one person. So you have to plan together, right? Because we have to know what's going to happen. We don't know who's going to get sick first, if anybody's going to get sick. So we have to be able to plan. So doing it together is definitely better. I know sometimes with second marriages and things like that, people will choose to use different attorneys, and that's okay too. But in most cases, I think it's easier to come up with a good, solid plan when they're using the same attorney.
And in speaking about second marriages, is it a good idea to think about this before you get legally married and meet with someone and understand what the legal ramifications are for your own estate plan?
Absolutely. And we've had people come in, we've had people come in and say, like, we're meeting with you to see if we should get married. I'm like, oh, no pressure, right? But I mean, yeah, and it's good to
Yeah.
have those conversations and make sure people understand like what they're gonna now be entitled to or their spouse is gonna be entitled to that, may not go to their kids and how, how everything should be structured to protect, protect them for whatever they want, right? To make
Mhm.
sure things pass the way that they want.
Great, great. Well, I shared your contact information, but the website is ConaElderLaw.com. I put that in the chat. Melissa Negrin-Wiener can be reached at mnegrin@ConaLaw.com. I also put that in the chat. I will also put all this information in an email that you will all receive in 24 hours. We'll also have the recording of this incredibly informative webinar so that you can rewatch it, you can share it with your family and friends. And we certainly hope that you do because planning is so, so critical and can sometimes be a sticky thing for people to think about. But I hope that this conversation has really opened and broadened your mind to make sure that you make this a priority, whether it's around the holidays or the new year, kick it off with making sure that you're protected. Thank you so much, Melissa. You are just such an incredible resource, and I appreciate your being so generous with your time.
Thank you so much. And I hope you all have a lovely Thanksgiving. You as
Yes.
well, Elizabeth.
Thank you so much. Same to you. Have a great day, everyone. Bye.
Bye-bye.